An overview of international organization law. International organization law concerns the legal framework governing entities established by states to achieve common objectives on the international plane. These organizations are distinct from individual states and other non-state actors, playing a significant and evolving role in the international legal system. This video highlights an overview of international organizations law. 1. Definition and nature of international organizations. An international organization is an entity established by agreement between two or more states, existing separately from its member states. They are also known as intergovernmental organizations. Key characteristics often include permanent association of states. International organizations are permanent associations of states with international legal purposes or functions, created by agreement. They are typically established by treaties, which serve as their constituent instruments or charters. However, some may arise from resolutions at international conferences or customary practice. Separate entity. International organization function as entities, separate from the member states that created them. Permanent organs. They are usually equipped with their own executive and administrative organs. A common structure includes an assembly, an executive organ, and an individual organ. Decentralized system. International law, including the framework for international organizations, operates within a decentralized legal system without a single world government or central lawmaking authority. 2. Legal personality of international organizations. The ability of international organizations to possess international rights and duties and to act on the international plane is known as international legal personality, limited and functional. Unlike states, which have unlimited legal personality, international organizations have a limited or functional legal personality. This means their rights and duties depend on their specific purposes and functions, as outlined in their constituent documents and developed in practice. Acquisition of personality, express recognition. Legal personality can be expressly granted in the constituent treaty of the organization, as seen in Article 39 of the ILO Constitution. Implicit recognition. Even without an express provision, states can implicitly endow an organization with legal personality based on its powers, purpose, and practice. The League of Nations, for instance, gained recognition through its ability to conclude international agreements. Objective international personality. The International Court of Justice, ICJ, in the Reparation for Injuries case, 1949, held that the UN possesses objective international personality due to its nearly universal membership and mission. This type of personality operates erga omnes, meaning it is recognized by all subjects of international law, not just its members. This decision marked a definitive pronouncement that an international organization can enjoy a degree of international legal personality. Criteria for legal personality. To enjoy a measure of legal personality, an organization generally must represent a permanent association of states with permanent organs or institutions that have international legal purposes, exhibit a distinction between its legal powers and those of its member states, possess legal rights and duties exercisable in the international legal system, such as treaty-making power or immunities, rather than merely within domestic legal systems. 3. Creation and powers, constituent treaties. International organizations are established by treaties that outline their organs, objectives, and duties. These treaties can be bilateral or multilateral. Treaty-making power. International organization have the capacity to conclude treaties to an extent determined by the rules of that organization and as necessary for the exercise of their functions and the fulfillment of their purposes. The 1986 Vienna Convention on the Law of Treaties between states and international organizations, or between international organizations, accommodates this view. Implied powers. International organization can possess powers not expressly stated in their charters, but which are conferred upon it by necessary implication as being essential to the performance of its duties. Lawmaking powers. While most international organizations adopt non-binding external acts, some, like the UN Security Council and the EU, have powers to adopt binding acts. International organizations also serve as specialized forums for states to conclude international treaties. 4. Immunities of international organizations. International organizations are granted privileges and immunities to ensure their independent and effective functioning. Treaty-based. These immunities are primarily regulated by treaties, such as the 1946 General Convention on the Privileges and Immunities of the United Nations, or by headquarters agreements with host states. They are not based on customary international law. Functional immunity. The purpose of immunity is functional, related to the specific tasks and functions of the organization, as set out in its constituent treaty. This prevents host states from interfering with their operations. Scope of immunity. International organizations are generally granted absolute immunity from all types of legal processes for acts carried out to achieve their purposes in host and member states. This includes immunity from adjudicative and enforcement jurisdiction, inviolability of property, and immunity from direct taxes and customs duties. However, they do not enjoy immunity for ultra-vires acts, domestic recognition. In the UK, the 1968 International Organisations Act governs immunity for international organisations to which the UK is a member. For non-member international organisations, the 1991 Foreign Corporations Act may grant legal capacity if the organisation is incorporated in a country with a stable legal regime. 5. Responsibility of international organisations. International organisations can be held responsible for their conduct under international law. Internationally wrongful act. An international organization commits an internationally wrongful act when its conduct is attributable to it under international law and constitutes a breach of its international obligation. Attribution of conduct. The conduct of an organ or agent of an international organization performing its functions is considered an act of that organization. Relationship with state responsibility. The International Law Commission has adopted similar rules for international organization responsibility as for state responsibility regarding attribution, breaches, precluding wrongfulness, and implementation. However, there are notable differences due to the international organization's distinct nature. Member state liability. Member states may also incur responsibility if they circumvent their international obligations by causing an organization to commit an act that would be a breach if committed by the state. States cannot avoid their human rights obligations by transferring functions to an international organization. 6. Historical development. 19th century origins. The first international organizations, such as the International Telecommunication Union, 1865, and the Universal Postal Union, 1874, emerged in the mid-19th century. Post-World War I, the League of Nations, 1920, was the first general international organization focused on maintaining world peace. The ILO, 1919, was significant for contemplating direct participation by non-state actors, employers, workers, unions, and establishing cooperative supervisory systems for labour standards. Post-World War II, the United Nations, 1945, followed the League of Nations model, becoming the main intergovernmental organisation with arms like the Security Council, General Assembly, and ICJ. This era saw an explosive growth in multilateral lawmaking treaties and the rise of international organizations, broadening the scope of international law to many aspects of human endeavor. 7. International organizations and sources of international law. Secondary law of international organizations. Acts adopted by international organizations based on their primary treaties are considered secondary law, while traditional views didn't classify them as a separate source of international law. The growing importance and universal membership of international organizations mean that their secondary law is now considered an important source of international law. Resolutions as evidence of customary law. Resolutions of international organizations, particularly normative ones from the General Assembly, can serve as evidence of customary international law. However, recommendatory resolutions do not produce direct legal effect. Hierarchy. The ranking of secondary law of international organizations depends on the organization. For example, resolutions adopted by the UN Security Council under Chapter 70 of the UN Charter prevail over other sources of international law. In conclusion, international organization law is a dynamic field that recognizes international organizations as distinct legal persons with specific, functionally determined rights, duties, and responsibilities, playing an increasingly vital role in shaping and implementing international law alongside states